Uh,
Today is Thursday, July 23rd, 2020. We're the Board on Professional Responsibility, and we are convened today for oral argument in the matter of Anita W. Johnson. This is Board Docket number 18-58, disciplinary docket numbers 2010-511, 2011-455, 2012-91, 2013-305, and 2016-382. Starting with disciplinary counsel, where the parties please identify themselves for the record. Oh, sorry, you're on mute. You're on mute, Mr. Link.
My apologies. Thank you, Mr. Chairman. My name is Miles Link. I'm representing the Office of Disciplinary Counsel.
Great. Further respondent?
Yes. Good afternoon, Mr. Chairman. John Iwanog on behalf of the respondent, Ms. Anita Johnson.
Excellent. Pleasure to see you both. So let the record reflect that Ms. Pittman, who is our vice chair, is recused, and so she'll not be participating in this case. Also, Mr. Link, you've heard me say this before. As everybody is aware, we're participating by Zoom. Zoom has many benefits, but some shortcomings. One of them is it can be difficult if two people are talking at the same time to figure out who's talking. So I would ask counsel and my fellow board members to be mindful to not talk over somebody else. If you are not talking, please have your microphone on mute so that there's not distraction or competing sound. Also, board members, if they have a question and are having trouble breaking in, are going to raise their hands. So counsel, if you see a board member with a raised hand, if you could give them a chance to ask whatever question they've got, we would be grateful. Any questions on that? And
no, Mr. Chairman.
Excellent, thanks. And of course, as with all things technological, if we have glitches, please be patient. The respondents has filed exceptions in this matter. I assume respondents counsel would like to argue first. Is that correct?
That's correct.
Great. You've got 20 minutes. Would you like to reserve some time for rebuttal?
Yes, I'll reserve 5 minutes.
5 minutes? That sounds great. The clock is almost ready for you. Yes, the clock is ready for you. When you're ready, please begin.
Okay. On this case, I will. I know that we have a limited amount of time to argue, but the case covers at least 5 separate cases involving 5 separate individuals. One of them actually has about 3. I'm going to try my best to be as precise as possible, addressing some issues, but I know that the brief that we filed was really expansive and covers a lot of the areas that we take exceptions to. Let me start off first with the case involving Mr. Lewis. With the case involving Mr. Lewis, there was a finding of an 8.4D violation about not appearing at the status hearing. The facts are pretty much not in dispute with respect to whether she appeared or did not appear. But I'll start out by saying that with respect to not appearing at the status hearing, that is not an 8.4D violation. Yes, we consider that Ms. Johnson did not appear, but then she had filed a motion to withdraw. And then subsequently following that motion to withdraw, the judge had not ruled on it, but then she had a conflict with another matter. Then she requested to be called on the phone so that she'll participate telephonically, because there was really not much for her to do in the Lewis matter other than the judge ruling on her motion to withdraw. And then if the board also looks at the documents that were filed in addition to the exhibits, but then most importantly, with the transcript and the testimony of the witnesses, specifically Mr. Lewis said, I received a letter from Ms. Johnson where I specifically said, Ms. Johnson specifically said that, you know, she will no longer be able to participate in the case and was going to file a motion to withdraw. Even if you look at the transcript from the hearing, Mr. Lewis even concedes to the judge that he could no longer pay Ms. Johnson to represent him, and then necessitating that he was going to proceed pro se. So not appearing at that hearing, even if she had participated by phone, because a call was placed to her, but unfortunately for her, she was not available because she had gone into the other hearing, and then the judge proceeded to ask Mr. Lewis some questions. And the questions that were posed to Mr. Lewis, one thing that stands out is that he volunteered the information that he was unable to pay the lawyer and was moving on by representing himself. I know that the hearing committee said that it prejudiced the client, but in reality, in looking through the record and then in representing Ms. Johnson at the trial itself, I couldn't really understand what the prejudice would be specifically to Mr. Lewis. Because one, if Ms. Johnson had appeared at that hearing, all that would have happened was she would have been allowed to withdraw because the client said I could no longer afford to pay her. And then I was going to continue to represent myself because Mr. Lewis represented himself in the proceeding pro se for a number of at least 2 years before he retained Ms. Johnson. So it wasn't like this individual.
Counsel, may I ask you quite a couple of questions here?
Yes.
Number one, given the confusion and the uncertainty about whether she was going to be able to appear or respond to a call, did your client file a motion to continue the status here?
I don't recall that a motion to continue was filed, but I know that certainly a motion to withdraw was filed.
But no motion to continue?
Not that I recall from the record.
And secondly, to your last point, you note that Mr. Lewis had represented himself pro se for the previous 2 years.
Yes.
Don't you think it's a fair inference that he felt that that was an inadequate way to approach this matter, and that's why he decided to then engage counsel to assist him? How can you really say that if someone decides to hire a lawyer, they don't really need that lawyer because they used to do it themselves? I don't quite see the sense of that argument.
I have always looked at it the way you articulate it. However, having practiced for 27 years and then talking to my clients over the time period, I have come to find out that there are myriad of reasons why they will seek a lawyer, either because the other lawyer is either harassing them or something to that effect, and then they need a lawyer to stand in between themselves and the other lawyer. Or there have been instances where they say, oh, okay, you can go out to retain a lawyer. I can show you that I can retain a lawyer myself. But then there are so many reasons why people go out to retain a lawyer. Just because you do a pro se for 2 years and then decide to hire a lawyer does not necessarily mean that you can then continue to have a lawyer if you're unable to afford it. But then in either circumstance, even taking it in the light most favorable to the point that you make, the fact of the matter is when the client says, I'm unable to pay the attorney, then the lawyer is then required to do two things at that time: either move to withdraw or continue to represent the client pro se, or you can take it another step further. You may refer them to either pro bono legal services or something to that effect. So even assuming that the client wanted her to continue, she couldn't really financially continue because that was going to affect her business and then her ability to pay her own bills. So yes, I get what you're saying, but then the second part of it is that the only reason this matter came to the issue of bar counsel and then became a matter that needed to be litigated as part of the bar counsel case is she never showed up for the hearing. But then I know that she notified the court about.
I believe Cassidy has a question.
Oh, I'm sorry.
Ms. Cassidy is also on mute. You could.
I'm now off mute. Thank you. Follow-up question on your points about not being paid. Are you suggesting that when a lawyer is not paid, it's solely their prerogative of whether they want to withdraw or move forward pro bono? Is it not the judge? Is it not the judge's decision to let a lawyer withdraw or not? I was hearing a suggestion perhaps that it was the lawyer's discretion of whether they stay in the case, not the judge's discretion. Can you clarify that a little bit for me?
Yes, let me clarify. That's not what I meant. If it came out that way, it was inartfully worded. No, there are instances, I remember this without talking about myself, in the Lakeisha Wilson Bay case. I never filed a motion to withdraw. I did it all the way to the end. So it is the prerogative of the lawyer to, the lawyer is required or ethically bound to file a motion. Whether you're going to be allowed to withdraw is entirely at the discretion of the judge. A judge may say that if a client is going to be prejudiced, if you cannot find alternate counsel or legal services corporation or somebody who can take it pro bono, a judge can still compel you to stay on with that case and then do it all the way to the end. So no, just because she filed a motion doesn't mean she's let out of the case. And I believe that's why she notified the court of a conflict with another case and then requested to participate by phone. And then if the judge had ordered her to continue with the case, she really had no choice, because at the end of the day, the judges are the ones that call the balls and strike. Yes.
I believe Mr. Bernstein has a question. Mr. Bernstein is also still on mute.
Got it. Okay. Thanks very much, Mr. Chairman. Mr. Awinogie,
Yes.
there are at least 3 allegations of violation of 8.4C,
Yes.
dishonesty. And
Yes.
it seems to me that the case very much hinges, at least to a large degree, on the hearing of the opinion of the hearing committee with regard to that. Could you speak to those, the opinions of the hearing committee on the dishonesty?
Okay. That was actually going to be my next point, and I'm glad you led me directly into it. What I find very confusing, I mean, for the past, since 1997, I've been reading a lot of these reports from the hearing committee in representing attorneys before the board. But what I find confusing about this one, and I'll highlight it with the dishonesty that they claim to have found, specifically on page 40, paragraph 69 and 70, they said they found, it's like a finding of dishonesty. And then one of the things that they listed as dishonesty is not disclosing something in the same level, conduct falling below the standard, that respondent failed to know her duties, and then did not know about filing a motion to withdraw. That's just one example. Even if you don't do something that is within the standard of care of all the practitioners in that area, that cannot be dishonest. It's either you know it or you don't. Just because there's a standard of care violation does not mean that the individual is dishonest.
I see your point. I guess as I'm looking at paragraph 69 and 70, I wonder if the reading is accurate. It looks like paragraph 69 is the one that talks about dishonesty, and 70 is the one that talks about violating the standard of care. I do take your point that violating the standard of care is not, incompetence is not dishonest, or at least not necessarily dishonest. But I think the conclusion is more based in 69, where a respondent claimed to disciplinary counsel on the committee that her client had disclosed his financial condition to the court, when the respondent provided much more detail than the client did previously.
That strikes me as one of those apples and oranges argument, or tomato. For example, what is at the issue is, was the financial information disclosed in an open setting prior to respondent? Yes, respondent looking upon it now may say, hey, I should not have put that in my motion. But then one cannot say that there's a violation of Rule 1.6 in that information was disclosed, because at the end of the day, what information that we're talking about, it is still the financial information that we're talking about. He volunteered it in open court to a judge. So when she puts it in her motion, this is information that was not only available to the hearing ear in the courtroom, but was also available to the judge and to the opposing party. So it is not like he disclosed, and that's where it's like the hearing committee is saying, oh, okay, he may have disclosed, but not at the same level. The fact of the matter is the information about financial condition was disclosed.
Okay, I believe it looked to me like Ms. Sargent may have a question, and Mr. Walker does.
Yes.
And Ms. Sargent is also muted.
I did have a question before that Ms. Cassidy, her question went to it, but since then I have another question, which is Mr. Wanagay.
Yes.
As I understand your point, what you're saying is that incompetence does not equate to dishonesty.
Yes.
Now, do you have an assessment of whether we have to rely on explicit findings of dishonesty by the hearing committee, or can we look to different findings and say that was dishonest? So in other words, the times when Ms. Johnson represented, made the representation to clients that she could competently handle a matter, and then she obviously couldn't. Is that something that we can look at in determining whether she was dishonest? And if the answer is no, can you explain why we should not do that?
Okay. I believe in looking, when the board gets these cases, they look upon the findings of facts and conclusions of law that were made by the hearing committee. If they believe that anything falls below the standard, at least with respect to the conclusions of law or the facts attributed, then the board can make its decision. However, in this particular case, for every instance that the board or the hearing committee says one thing as to what the facts were, there's something else that contravenes or contradicts that fact. A good example is on page 13, on page 13, paragraph 13 of the board's, the hearing committee's finding. They take a legal conclusion and make it look like a fact or a proven fact. But then that is the legal conclusion that is not fact-based.
Let me, if I may, I know we're almost out of time and Mr. Walker had a question. Why don't we go to Mr. Walker's?
I'm okay without asking it at this point.
Okay. Well, we're just out of time. If you want to take a few seconds and sort of sum up, and then we'll hear from disciplinary counsel and come back to you.
Okay. In going through all the cases and then looking at our brief, we specifically addressed a whole host of issues. And in looking at every issue that we addressed and considered the ones that we felt she didn't do right, and then we argued the ones that she felt that were mistakes, that were not violation of either 8.4 C or D. In looking through it, not believing Ms. Johnson is one thing, believing the Gosses or the Rodders or any other person or the Stroder or Mr. Stroder is fine. However, equating that to mean that she was dishonest, looking at the entire record, doesn't make sense, for lack of a better way of putting it. Specifically, if you look at the analysis of the entrusted funds, you say, okay, she submitted the records. You say it is so confusing that nobody can make sense of it. Then if you say that the record keeping is poor, that's understandable. We admit that the record keeping in our brief as well, and in arguing that the record keeping was not the best. However, to say that that is something that rises up to the level of where she was trying to either confuse, mislead, or obstruct bar counsel defies logic.
Okay.
But
Thank you very much. At this point, why don't we hear from disciplinary counsel, Mr. Link? You'll have 20 minutes as soon as we get the clock all set up. 2 minutes away. Excellent. Whenever you're ready, please feel free to begin.
Thank you, Mr. Chairman and members of the board. This is a case where we have a respondent who committed multiple violations of 20 different ethics rules involving 6 different clients involving 5 clients in 6 different matters over a period of 6 years. After which, for the next 6 years, she committed violations involving the Office of Disciplinary Counsel, impeding our investigation, and then falsely testified before the hearing committee. The hearing committee's report is 147 pages long. They were painstaking in their attention to detail in addressing the issues presented by the multiple violations of this respondent. Going back to my learned friend's discussion of the Donnell Lewis matter, it is not a defense to an attorney's violation of his or her ethical obligation under 1.6 to disclose client secrets or confidences, to say, well, the client made a general disclosure and therefore it's okay for me to make a more specific disclosure. That was made without informing the client, without the client's permission. That was a violation of one of the most fundamental principles of the rules of ethics. In Ray Scott, the Court of Appeals said that multiple violations in many different matters, when considered together, can justify the most severe sanction. And that's what we have here. The sanction of disbarment is entirely appropriate and, in fact, absolutely necessary in this case. We do not want to inflict on the public this lawyer anymore.
Mr. Can I let me ask you this? Because I think it's something that's important. Can we support a recommendation for disbarment if there's neither intentional nor reckless misappropriation, and if we don't find that a series of incompetent representations equates to flagrant dishonesty, or if we don't find that what ODC disciplinary counsel characterizes as impeding the process there, or if we find that there's just not enough of the sort of gravamen of false testimony before the hearing committee to find flagrant dishonesty, because there's other times where there might be a finding by the hearing committee that they didn't find an explanation credible, but it doesn't support a flagrant dishonesty finding. So if we find that there's neither flagrant dishonesty nor the level of either intentional or reckless misappropriation, do we have a basis to support the recommendation of disbarment on other grounds? And if so, why?
Thank you. I think the answer is, and the office thinks the answer is clearly yes. The court has upheld disbarment for violations where misappropriation was not found. For example, in Ray Corizzi, C-O-R-I-Z-Z-I, respondent was disbarred for violating rules 1.3, 1.4, 3.3, 3.4, but not 1.15a. And in Ray Pelkey, P-E-L-K-E-Y, the court found that disbarment was appropriate. In neither case was 8.4 implicated. And in Ray Goff, G-O-F-F-E, the court upheld disbarment for multiple violations of by a respondent. And in Ray Foster, an earlier case, we had an attorney who violated 23 different rules. We have here 20. I suggest that's not a difference, it makes a difference. But there was dishonesty found in that case. I think it's hard to separate this respondent's dishonesty, not just to the hearing committee and to disciplinary counsel, but to her own clients. As Ms. Sargent, you noted before, she misrepresented to her clients her ability to handle cases. For example, when she represented Mr. Strotter, she had never handled a complex medical malpractice case before. She represented him in a case in which two other lawyers had already refused the case. 2 experts refused to testify, and yet she assured Mr. Strotter she could help him when in fact she could not. He ultimately had to get other assistance.
I believe
And
Mr. Walker has a question.
I'm sorry, Mr. Walker.
Thanks. Mr. Link, could you focus on the findings of dishonesty to and before disciplinary council, your office, and the hearing committee? Can you summarize for us what the findings are there, A, and B, if we have problems with those findings, do we nonetheless have a basis to find flagrant dishonesty? So that's B. So, yeah, the disciplinary council hearing committee findings with respect to dishonesty and how that factors into the flagrant dishonesty equation.
Thank you, Mr. Walker. Before the hearing committee, the hearing committee found that she testified falsely as to what she had informed her clients in multiple cases, including Donnell Lewis, including Ms. Wilson, and including, of course, the case involving the family that had a matter of, were accusing the police of police misconduct, the Rudder family, as to what she had disclosed to them during the course of their representations. The hearing committee heard her testimony. They heard the testimony of the other witnesses. They concluded her testimony was not credible and it was false. With respect to the Office of Disciplinary Counsel, her provision of financial records was incomplete. She ultimately ended up providing 2 sets of financial records and tried to argue between one and the other which one was accurate. And also to disciplinary counsel, she testified falsely, explained falsely, tried to defend falsely what her conduct had been with respect to the clients she had represented. So those are sort of, and the hearing committee lays out in their report, as for example, as was pointed out earlier on page 40 with respect to Mr. Lewis, they lay out in their report the examples of dishonesty they found with respect to her testimony. In turn, if the board is defined, were to find that somehow she was not dishonest, despite these findings, despite the clear evidence in the record, could they nonetheless recommend disbarment? We would argue they could. Why? Because the number of violations is so substantial and so sustained over a number of years. These are not isolated instances. This is someone with a pattern and practice of misconduct that frankly and candidly should not be inflicted on the public. Again, suspension is not appropriate in this case. There is no reason to think this misconduct will not be continued if this respondent is allowed to practice again. Therefore, when you look at the record and look at the record in its totality over the range of cases and over the range of time that this took place, disbarment, serious option that it is really the only appropriate option in this case. I hope I answered your question, Mr. Walker.
You did, Mr. Link, but let me take the opportunity to ask something else with respect to the range of charges. A couple of those charges, the commingling charge and the misappropriation charge, seem to be based on facts or on findings and on conduct, not really identified specifically in the specification of charges. The misappropriation was found with respect to the Hart client, Hart, and that was not she was not specifically identified in the specification of charges. And a similar issue with the commingling. Is there an issue of, first of all, due process with respect to those findings by the hearing committee? Does that affect then this finding of a range of violations?
Thank you, Mr. Walker. It's interesting that on those two findings, although respondent objects on other grounds, she doesn't object on the grounds of lack of due process. She had ample opportunity to defend on those findings or defend on those charges, and that information was discovered in the course of the subsequent testimony and the subsequent documentation she provided. One of the things the hearing committee points out is that the poor record keeping was so substantial and so considerable and affected the ability of the hearing committee to make its determination that a 1.15a violation for commingling was inevitable based on that record. In addition, on the misappropriation, we disagreed with the hearing committee with respect to the Arigbe couple. We believe there was misappropriation there. The hearing committee found that there was not clear and convincing evidence of misappropriation. We would suggest to the board, if you look at the record, you will find clear and convincing evidence. And at the least, her characterization of certain payments as checks when they were transfers and as legal fees when they were client entrusted funds. With respect to the art matter, both the board and disciplinary council found, we argued, the board found that there was, and concluded that there was misappropriation with respect to that account. The board found that the misappropriation was negligent and not intentional or reckless. We would suggest that at the very least, it should have found reckless misappropriation given the way in which respondent maintained her records and her inability to clearly explain and clearly point to the transactions, checks going in and out of her different client accounts. Nonetheless, the board found, the hearing committee found misappropriation, but it found it that it was negligent.
I believe Mr. Bernstein has a question. And also if I could ask a respondent to mute your microphone. We're getting a little bit of background noise.
Okay.
Bernstein?
Yeah. Yes. My question is this: you were relatively adamant earlier on when you indicated that absent a finding of dishonesty, the weight of misfeasance over a number of years would lead one towards disbarment in any case. Could you go through that, please?
Thank you. And misfeasance is a good word. I wish I had used it. The weight here, when you look at the different cases, one of the most interesting cases, I think, is a case we haven't discussed. This was a case involving Miss Wilson in two matters, one of which a child custody case. What could be more urgent than a child custody case, a mother trying to regain custody of her child? And as the case proceeded toward trial, the respondent essentially abandoned the case after Ms. Wilson had paid her $16,000 in legal fees to take up an adjunct teaching position somewhere, referred Ms. Wilson to another lawyer who wanted to charge her $20,000 to take the case. Ms. Wilson then decided she had to do it on her own. She couldn't afford to pay another $20,000. She took the case, found out there were all kinds of discovery issues that Ms. Johnson had left unattended to in the case. Nonetheless, she proceeded in the case, proceeded to the hearing, and against all odds, she won. She won custody of her child. But because of the respondent's failure to abide by discovery rules, she was assessed, Ms. Wilson was assessed a penalty of $1,600, approximately that amount. In penalties she had to pay for Ms. Johnson's failure. She had to pay that. Ms. Johnson has never refunded that fee to her. That's just one example. We talked earlier about the Redder case, where Ms. Johnson agreed to agreed to a dismissal of the child's claim, common law claim against the District of Columbia, when that claim should have been preserved. The judge was amazed that that agreement had been given, but nonetheless, once counsel had agreed to it, had to dismiss all of the claims in that case. The parents' claims were time barred by the statute of limitations, but the child's were not. That family had to take it, and Ms. Johnson never told them about the dismissal. They had to find out about it elsewhere. She then filed a motion without discussing with them to try to get the court to reconsider its dismissal, did that without consulting with the clients under Rule 1.2. The clients then had, the court decided to not reconsider its order. The clients then had to retain new counsel on appeal to the U.S. Court of Appeals to the DC Circuit to get that decision reversed so they could have a hearing on the merits of their claim. Those are just two examples of the fundamental problems here. In the Strouder case, Mr. Strouder had a retinal damage to his eye, a serious medical malpractice issue. Whether there was a claim there is another matter. In fact, he had gone to lawyers who were experienced in this type of care. They didn't think he had a claim. He went to Ms. Johnson. She took the case. She then went to two experts who declined. They said they didn't think there was a medical malpractice.
Okay, I get it. And your argument is a good one. But my point is, absent the finding of dishonesty, why wouldn't a extremely long suspension and a finding of fitness be appropriate?
There's no reason to think, and I want to be clear, disciplinary counsel takes no pleasure in saying this, but we have to say it. There is no reason to think this type of misconduct will not continue. And the court has said, even where flagrant dishonesty is not found, where you have violations of such continuing seriousness over such a period of time, where there's no evidence that this is something that for example, here we do not have a respondent who has admitted to her misconduct, who has tried to atone for her misconduct. If she had repaid Ms. Wilson for the penalty Ms. Wilson was charged for her misconduct, we might be having a different discussion. If she had done other steps to indicate she accepted what she had done and she was trying to atone for it and trying to do better, we would be having a different discussion. We are not having that discussion. She has never done that. There is no reason to think this won't continue. And so we have to ask the board, do you want to inflict this respondent on other members of the public?
Mr. Link, I believe Mr. Walker has a question. Mr. Walker.
Yes, thanks. Mr. Link, first of all, just quickly, you're not conceding the flagrant dishonesty argument here, are you?
No, we are not. I was simply responding to the question as it was posed, but we are not. We believe it was flagrant.
And then with respect to your alternative argument, given the wide range of misconduct, does that, for your argument to apply, does that require us to agree with all of the violations found in each instance? Specifically, for example, does the conclusion and finding with respect to the Harris matter, is that necessary to your argument of kind of sustained misconduct, that serious interference with the administration of justice, or is that kind of separate from your analysis, your alternative analysis with respect to the conduct?
Mr. Walker, thank you. The Harris matter, she lied about what she knew and about what she had received from Ms. Harris. Now, what the board may conclude is that that lie was not somehow serious or somehow that was a less culpable. I don't know how the board could conclude that, but I defer to the board on its conclusions. If you set that aside, then you still have the other instances I've already mentioned and others which we don't have time to address. And in fact, the interesting thing about the Harris matter was that the lie was unnecessary. The dishonesty was unnecessary, and yet it was engaged in nonetheless to try to make her look better. Mr. Walker, I would suggest to you, you've sort of hit upon an instance which indicates why a suspension is not appropriate. There's no reason to think this is going to end. And why should we have other Miss Harrises have to go through this?
Excellent. Thank you very much. I believe there's 5 minutes reserved for rebuttal. As soon as we get the clock ready to go on the 5 minutes, you can start at your leisure. Excellent. Whenever you're ready, please go ahead.
Okay. Let me make a correction, but I think the correction is that in the Rhoda Goss case, it was actually Miss Anita Johnson, upon discovery of the dismissal, was the one that filed the appeal to the DC Circuit Court of Appeals. It wasn't done by another lawyer. It was actually done by Ms. Johnson. So I believe Office of Disciplinary Counsel may have.
Was that done with or without the client's consent and knowledge?
At the time that the appeal proceeded, it was done with their consent and knowledge, because she told them that an error was made by the trial court and she was going to seek it to be reversed by the Court of Appeals. And the Court of Appeals did reverse it. And then with respect to the minors claim, because the Court of Appeals said that the judge was in error by dismissing the claims dealing with the minors. In reference to the Strada case, bet for Ms. Johnson, after getting notes from 2 experts, but was able to find an ophthalmologist, another lawyer that took on the case right after would not have been able to resolve the case. The finding that she was dishonest because she brought to the attention of the client a way to finance the lawsuit, because remember, he specifically, Mr. Strada, said he was so angry at Dr. Desai because he's done this to so many people and was basically going after him. So he was willing to do anything, because as he testified on the oath at the hearing, it wasn't a matter of dollars and cents for him, but it was just going after Dr. Desai. So get additional funds. I don't see anything that is dishonest in a non-recourse loan. They seem to confuse it that this man, Mr. Strada, would have been responsible for the money if there was no discovery. So Ms. Johnson protected the case based on what the client wanted.
Let me ask you know, a lot of your arguments are challenges to the factual findings of the hearing committee. And I appreciate that. The standard we have to apply is whether those are supported by substantial evidence. And the Court of Appeals has told us that that test doesn't mean, it could be that those are supported by substantial evidence, and opposite findings of fact are also supported by substantial evidence. Our test is, as we've been instructed, you know, it's meaningfully deferential to the findings of fact of the of the hearing committee. And so I guess in light of that, and in light of the, you know, so where we are on the flagrant dishonesty, I guess, do you have an argument if we wind up agreeing that, or we wind up determining that the hearing committee's facts are supported by substantial evidence? Do you have an argument that disbarment is not the right sanction?
Yes, that's the thing I was going to get to last. Yes. My argument is in looking at the cases, the specific case that comes to mind is the Ekekwe case. If you look at the Ekekwe case, this is an instance where a case was dismissed, and then Ms. Ekekwe Kaufman was even still collecting money from the client. The conduct involved, or the conduct involved in this case, only happened between 2008 to 2013. Subsequently, the hearing was in 2019. I don't see any other violation that was brought to the attention of the Bar Council or that was brought to the attention of anybody other than the incidents that we have The only one is the one involving Ms. Harris.
Your argument is the misconduct and dishonesty, if we agree with the hearing committee on it, merely spans 6 years and then happens again in 2019.
No, it spans from 2008 to 2013. The only thing that was in 2016 was a letter that my client wrote in response to a letter from an inquiry from another lawyer in reference to Ms. Harris. Other than the letter, there's no conduct on her part. Other than, so if you calculate the time, it's actually 5 years, but then you can say 6, but nothing in 2019. Everything is 2013. The only thing in 2016 is Ms. Harris, in reference to something that my client didn't know about in terms of somebody writing and saying, I have not heard from you, you're supposed to be my lawyer, to which he responded, please, we are no longer your lawyer. And then in looking at and listening to what Mr. Link said, and I echo that the lie is unnecessary. The question is, what makes it a lie? She was responding to the letter that was written, and then back counsel makes an inquiry. She has no relationship with this individual. So it's not a lie. It's unnecessary. And then if it's unnecessary, why would she tell a lie when there's no reason to lie? And this is in reference to the Harris case.
Right.
So,
all right. Well, thank you very much for your argument. Thank you both very much for your argument. The case is submitted. One thing I want to say in this public forum, this is our last oral argument with one of our very valuable public members, David Bernstein. I just wanted, while we're here publicly, to thank him very much for his 6 years of exceptional service to the board on professional responsibility. It's a volunteer position. It's a lot of work. We couldn't do it without public members who are willing to volunteer. David, thank you very much for all that you've done for us over these last 6 years. Great. We're off the record.
Thank
You're
you
here.
very much